Good afternoon, Chief Justice Marshall.
Good afternoon. Good afternoon, Mr. Thompson.
It has been a long morning. I represent the defendant, Jerry Campagna, in this appeal from the denial of a petition for relief under Chapter 211, Section 3. The gist of both of our claims here is that double jeopardy bars the retrial of the two remaining indictments in this case because the evidence submitted in support of each of those indictments was constitutionally insufficient to support a conviction. The case comes up to this court as a result of the Commonwealth's charging strategy backfiring during trial. There was, according to the trial judge, the Commonwealth presented evidence to the grand jury that warranted a single conspiracy indictment and a single theft of controlled substances indictment. But the Commonwealth indicted the conspiracy as 7 separate conspiracies, as if there was a separate agreement made with regard to each of 7 transactions that they had evidence of. The defense the defense objected to the joinder of these cases under Rule 9E, arguing that the theft charge was a substantive offense under the conspiracy. And under Rule 9E, the defense had an absolute right to refuse to have that case, the theft charge, joined with the conspiracy trial.
So given that, and given the dismissal at the end, why wasn't there manifest necessity at the end to do that?
There wasn't manifest necessity as regarding the theft indictment, Justice Botts, for 2 reasons. One, the evidence was insufficient. And my basic position here on Rule 25A in both cases is that at the close of the Commonwealth's evidence, when a motion for required finding of not guilty is made, that is the next item on the agenda. And that's an issue that must be resolved before the trial moves forward on any other issue. So my first response to the question of why there's not manifest necessity is there wasn't enough evidence to submit to the jury. There'd been that case had been tried. There wasn't enough to go ahead with, so there wasn't, because manifest necessity implicitly contains the statement that there will be another trial.
I understand.
Secondly, as far as the theft, again, on manifest necessity, the judge did not go through the process that is required to establish manifest necessity, and as a matter of fact, he did not find manifest necessity. Manifest necessity was a finding made by the single justice. The trial judge found consent to the mistrial, and that was, I think, a clearly erroneous finding. What happened was, after the defense counsel had made his motion for a required finding of not guilty, the judge said, well, I first want to deal with the severance issue. And counsel said, I think you're required to deal with the sufficiency of the evidence first. The judge said, I'm going to give you a choice. You either have to stand on your objection to joinder, or we're going to, and we'll mistry the case, or you have to let it go to the jury. Defense counsel said, I do not want a severance at this point. He had moved for a severance, or that is, he had objected to joinder before trial, and during the trial, at the end of the 4th day, the issue had come up again. The judge was struggling with an effort to understand what the Commonwealth's charging theory was. That is,
So are you saying that the single justice, I think it's in the memorandum when he says that the defendant stood by his motion, that is the motion to sever, I take it.
Yes.
That's not correct?
That is correct.
But I thought you just said that the defense counsel said, I don't want a severance.
He did. He said, I do not want a severance at this point, but he didn't want to waive his joinder issue. He understood the judge to be saying, you either have to waive the Rule 9E objection and go for and send the case to the jury, or you stand on it and we declare a mistrial. And those were the only 2 alternatives that were discussed. So the first thing that the trial judge is supposed to do is convene a hearing and discuss the alternatives. And in this situation, it's very important that the defense counsel have the opportunity to have at least a say in what's going to happen, both under Rule 9E and under the case law at the point of where the severance issue comes up. The defense counsel is supposed to have some control over the course of action, because here some important rights, constitutional rights of the defendant are at stake. One is the double jeopardy right to have the case completed, to have the trial completed with this fact finder that he has been put before, in this case against his choice. He didn't have the opportunity to assert and vindicate that right. He did specifically say, I think the first issue is the sufficiency of the evidence. And I think that if the trial judge had addressed the sufficiency of the evidence at that point, a proper ruling would have been the evidence is not sufficient. He should have entered a required finding
May
on the
I
theft.
ask you about the sufficiency of the evidence? Apparently, there's a videotape.
Yes.
Do we have it?
I don't believe that it is in the record.
Well, is it available?
I'm sure it's available in the clerk's office, and I can make arrangements to make sure that the court sees it.
That would be good.
It was presented to the jury, but in the transcript there's some testimony about it, but it's not clearly described.
I think the answer is probably no, but I don't know. Does the videotape in any way show whether the bottle that was put into the trash was a prescription bottle or a pill bottle or something else? I mean, some other kind of bottle?
I have not seen the videotape myself, Justice Botsford, but in Mr. Downing's testimony about that, Mr. Downing was the owner of McClellan Drug. When the videotape was presented, at first, Mr. Downing was testifying about what was in the videotape, or what he perceived to be in the videotape, and later on defense objection, that was stopped. But while he was commenting on the videotape, he was asked, can you see a prescription bottle in his hand? And he said, not at this point. So
it's that bottle that went into the trash?
A bottle went into the trash. And from the transcript, it appears that it's not possible to observe whether that was a filled prescription bottle or whether that was an empty source bottle, which you might call the source bottle. That is because the prescription was for 150 pills. They came in bottles of 100. So more than one source bottle was exhausted to fill the 150 pill prescription. So what went into the trash was either, it was a container of some kind, but it's not clear from, at least to Mr. Downing, in his looking at the tape, which kind of bottle that was.
But even without the videotape, isn't there sufficient evidence for the jury to infer that the defendant took the prescription bottles? Because there's evidence that the pills were never picked up, they were never paid for, they weren't found in the store, and the person for whom the defendant filled the prescription testified that she never used that pharmacy. Isn't that sufficient evidence then for the finding that it doesn't matter what the videotape shows?
I don't think so, Justice Cowan, for this reason. This is the inference that's being pursued here, that's being sought, is on an element of the offense, that is, taking and carrying away, asportation. There's no evidence that Mr. Campagna touched this bottle again after it went into the trash. We don't know what happened to the Azarian prescription, but we don't even know whether the bottle that went into the trash contained the pills that were the subject of the theft accusation, the theft charge. So there's two steps of speculation between the evidence and the conclusion that has to be drawn beyond a reasonable doubt. The first step is, yes, this was the bottle of prescription pills. The second is that Mr. Campagna is the one who removed it from the trash. There's simply no evidence on either point. So even with everything that was presented, I suggest that there's not sufficient evidence to conclude beyond a reasonable doubt that Mr. Campagna took those pills from the pharmacy. Now, as far as count 1 goes, there were 7 indictments that were submitted, 7 conspiracy indictments that were submitted. Each one of them alleged a separate agreement, and the judge found that none of those agreements was proved. Under the Cerveny case, he was required to enter a finding of not guilty on each one. He entered a finding of not guilty on 2 through 7, but not on 1. He chose 1 arbitrarily, indictment 1, to embody the overall conspiracy. That simply was not a charge that the grand jury ever made. I think that it's clear from the grand jury, the piece of grand jury testimony that's in my brief and that's in the record, that the grand jurors themselves asked, why are we charging 7 indictments? The prosecutor broke down this one conspiracy into 7 components deliberately. None of those 7 agreements was made. And under the Cerveny case, the requirement at the point where a required finding of not guilty is made, what the judge was required to do was to enter a required finding on each of those 7. He was not at liberty to amend the indictment on his own order. And so that indictment, that is the indictment 1 as it exists now, cannot be tried because it's not an indictment that was returned by a grand jury.
Thank you, Mr. Thompson. Mr. Peterson?
Thank you, Chief Justice Marshall. Good afternoon. My name is Jim Peterson. I'm from the Berkshire District, and I obviously represent the Commonwealth in this case. I'm here today to ask you, this court, to affirm the single justice's decision in this case, that the single justice did not abuse his discretion, did not commit any errors of law when he held that the trial judge properly followed the procedure that was laid out in Cerveny, when he concluded that the facts actually showed one overarching conspiracy rather than 7 separate conspiracies, when he held that the trial judge properly declared a mistrial on count 8 at the end of the Commonwealth's evidence, and when he held that the double jeopardy does not prohibit the Commonwealth from retrying the defendant.
What do you say to Mr. Thompson's point that there isn't any evidence that the bottle in the trash was a filled prescription bottle or of asportation?
I would suggest first that that is something, and I have not watched the video either. My information comes as well from the transcript, and from the transcript it does appear that there isn't direct evidence in there that that is a full bottle. So it's clear, it seems to be clear that whoever's watching this can't say with absolute certainty, I see a pill in there, or saw him put a pill in, that's what was thrown away. What he can say is he throws away the pills into this trash, which other people testify is only emptied by people from the pharmacy staff, and one person.
Right, but there are, I mean, you have to get there are source bottles that need to be thrown away, right?
Yes, and in the light most favorable to the Commonwealth, this is one where there is, the other evidence was essentially that those pills disappeared. If they weren't in that trash, nobody picked them up. They weren't anywhere else. In fact, the person who, the owner of the store who was watching this video, saw it being thrown in there, went and actually looked for that prescription, because from noticing the defendant's brief that there is the suggestion that perhaps, that essentially suggesting that it is mere speculation whether they were thrown away and stolen or whether they were actually put out. It could be one or the other is a suggestion. I'm saying that the evidence, certainly in the light most favorable to the Commonwealth, is that that is not the case. He searched the next day. It wasn't picked up. It wasn't where it would have been if
What wasn't picked up?
The prescription, the Azarian prescription, which was what was being filled out at the time when somebody was thrown in the trash, that wasn't picked up. It wasn't where it would have been. Had it not been picked up, apparently there was a location to place these things, it disappeared. There was no signature for how those pills left. In other words, the pills, it was filled out, and then what was there
We know
didn't
it was-
go anywhere except something went into the trash, and then it was gone, emptied by somebody who, again, in the light most favorable to the Commonwealth, would be the evidence that it was the defendant who emptied that trash, as not everybody was allowed to do so, and that, therefore, in the light most favorable to the Commonwealth, it certainly was enough to get beyond a finding a reasonable doubt that he could have been the one who stole those pills, and it was, of course, our theory, too. But there isn't like an equal speculation, which is what I believe the defendant is trying to say, that they could have been placed out, because there was evidence that that's precisely what didn't happen, that those pills weren't placed out, they weren't picked up, and
What
they
do you mean
weren't
by placed out? You mean
placed out to the area where they would be ultimately dispensed to the person, in this case Azarian, who never did fill prescriptions there, but Azarian, or even somebody posing as Azarian, they weren't ever placed out there. They weren't ever picked up from that area. They weren't ever in the area where they would have been had they been placed out. They disappeared. And from that, you can, the inference is that in that bottle, that's what the pills were in there. And based on that, that's how the Commonwealth, we did show that it isn't an equal likelihood in that space.
In a trial just on the one offense, would the other prescriptions be admissible that were written by the co-conspirator, and that the number, and also the evidence that after the defendant left the pharmacy, the number of prescriptions filled for that doctor's office dropped immensely?
And so in the, simply for the count 8, the
Yes.
theft of the drug charge, I believe that the short answer is I don't know. There would have to be some evidence that would clearly be over and above simply, here's the videotape, watch it, and let's draw a conclusion based on the very limited. But of course, you can't just have prior bad acts. And the whole point of severing the substantive offense from the conspiracy is precisely so you don't get that bleed over into that. I don't know where that line is, frankly.
Was there evidence of any pattern or practice by which they would use this method of putting pills in the garbage and later picking them up, or is this a single instance?
It appears, no, there was no direct evidence. It appears to have been a single incident. It's not really clear, and I believe that's precisely why, if you notice, the Commonwealth did try this and said this is not a substantive offense. Under the Commonwealth's original theory, the prosecutor's original theory, essentially, just to clarify that from the reading, and I believe the single justice also clarified that to some extent, because it's not very clear from the transcript at the first read. The original theory was that there was an agreement between the co-defendant and this defendant, the pharmacy and the doctor's office, for each name. So they may have an agreement for example, Azarian, just because it's the only name I can think of offhand, that's an agreement. Every time they fulfill a prescription for Azarian, this defendant would know when it came in that this is an agreement, we're going to have an ongoing conspiracy. Then it's Mr. Smith or whoever comes in next. There had to be an agreement so that there would be a knowledge of who it is, and that's where these came from. That this would be a conspiracy to fill these prescriptions for people who weren't actually coming there, but not by taking them, by then filling them and then throwing them into the trash. That's why the prosecutor felt that act itself wasn't part of the conspiracy at all. This was over and above. This is how he was going to take these particular drugs when, of course, the trial judge determined this was one overarching conspiracy between these two people just to take drugs, steal them pretty much in any way, and cover their tracks with these false prescriptions. That's when he said, this is a substantive offense to this. He's taking this drug. It doesn't matter how they get it out. It doesn't matter if the normal way of getting it out is to put it up front and have somebody pick them up and sign for it that way. The point is get them out. Get them out of this area and into their hands and account for them. He didn't say it in those words, but that's the essence of what he was trying to say.
And I'm trying to be clear on this. I gather that the conspiracy was that there was a doctor and a pharmacist, and whenever a certain name was used that was known to be a bogus name and not a true prescription?
There were several. There were actually the co-defendant wasn't a doctor. She actually worked in a doctor's office. There was evidence this doctor was extremely busy and apparently not according to practice or proper practice, would just sign prescription pads. Tell the nurse, look, this is what I did. This is what fill out the rest of this, get it to the pharmacy and go. So there were these signed prescription pads from a doctor who wasn't actually involved in the conspiracy. The co-conspirator, Ms. Gomez, who worked there at the doctor's office, would take these and fill them out in the names of people either who, I can't recall if anyone were actually fictitious or if they were people who went to that doctor's office where they either filled a prescription right there or where she knew these people went to a different pharmacy altogether.
Okay.
Then they would take
Was
them.
Azarian one of those names?
Yes. And in fact, Azarian testified, and if I recall correctly, she said she had been in this defendant's drugstore once, not to pick up drugs, but she knew where it was. She'd been in there once, but that she filled her prescriptions in the South County, so the south half of our county, in Berkshire County, and not in Lee, where this pharmacy was actually located. And that was essentially what was going on for each of various names, including, in fact, Ms. Gomez, who appeared on this as well. She had several that were legitimate prescriptions. There were certainly some that were absolutely legitimate that we didn't contest were legitimate, but there were also some that were also part of this conspiracy in her name, in a co-conspirator's name.
And how do we know from that videotape that the prescription being done was the Azarian prescription?
I was a little unclear. I'm a little unclear, but I think what was happening is that this is all recorded. Both there's a time on the video where it's clear what time you're watching, and there's information entered onto a computer at the same time. So it was very clear.
You mean as to when the prescription is filled?
Yes, right. Oh, yes, right. When they actually fill the prescription, they're doing something on a computer at the same time as this videotape was actually videotaping them. And I believe, if I understand correctly, and I don't want to hold it out as I'm absolutely correct, but that's how they knew precisely which prescription was being filled at that time on that video, because he looked and said, wait a sec, and he could compare that to what the computer said was being filled at precisely that time.
I'm having a little bit of difficulty understanding why the judge dismissed 6 of the 7 conspiracy indictments when he found that there was, or he believed there was one overarching conspiracy that could have, I take it, subsumed all of those. Did the Commonwealth object to the dismissal of the 6 smaller conspiracy indictments?
The Commonwealth, actually, all the way through this, and even at the decision, was still of the opinion. The prosecutor was very clear that he was of the opinion this still was 7 separate conspiracies, and he was going to wrap this up in closing argument and show precisely what matched with what. So he did not agree with the judge's decision. I don't think he ever explicitly expressed, certainly not in those terms, that I disagree with you dismissing 6 of these 7 because this is your claimant, this is all one overarching conspiracy. He didn't agree with it. It made it very clear that he thought that there were 7 separate ones, and that he didn't agree that the trial judge's decision was appropriate. But he also was somewhat deferential when speaking to the judge. And I believe it said, we disagree, I understand that, you're going to make a ruling, and it seems that we are on opposite sides again, and I understand, you're going to rule. So he was deferential to what was going to happen to some extent, but did indicate that he didn't agree with that to a great extent.
But the conspiracy indictment that survived identified a very narrow period of time in a specific transaction, not a broader picture, I take it.
That was the language of the conspiracies. All 7 conspiracies are actually worded identically. And they are worded that essentially in an 18-month period of time between, I can't remember the exact dates, but approximately an 18-month period of time, Gomez and this defendant conspired to fraudulently obtain drugs.
So there aren't specific
That's correct.
sub-periods?
That's correct.
So one indictment would cover the whole time period?
Yes. The actual indictment, as they were drafted, and there was an entire discussion at the beginning of this about bills of particular, and actually ongoing through this as to whether one was actually done for this defendant or not. which is still a little unclear whether it was represented it was done for him or not. There was certainly one done for the co-defendant, but it didn't do anything to clarify this question, this issue. The language is very broad. It's from the beginning to the end. It did do it. So the language of all 7 is identical. The defendant, but the
Was there a bill of particulars, or do the grand jury indictments show 7 different transactions?
Well, and this is something that the defendant has raised in the grand jury proceedings. There was a question as to what exactly the 7 were. And the grand jury was clear that one of the, at least individuals, grand jurors, was clear that there was what are we talking about with 7? I see conspiracy. I don't see, wasn't trying to get to it. The prosecutor did ask several questions of the witness on the stand at that time to try to narrow it down. And I would suggest that it really does have to be taken as a whole, because based on just that little narrow re-questioning, which I think we've both cited a little bit in our briefs, it's not, and certainly the defendant has, it's not a direct, solid answer. I think it comes in with all of it, that he did present that there were there's multiple names, and I believe this is also what the single justice was discussing as well on this. There were multiple names on here at that time. It was clear that they...
But was there a bill of particulars as well?
There was a bill of particulars for the co-defendant. Apparently the prosecutor physically gave that to this defendant's attorney, but not in response to a bill of particulars. In other words, it wasn't actually a physical response, and apparently wasn't filed with the court. It's a little confusing. The prosecutor, at least that was his opinion. I didn't file this with the court. This was not an actual response. He just said, can I see a copy of the bill of particulars you gave the co-defendant? And I gave that to this defense attorney. Again, the actual bill of particulars it pretty much says what the indictment says, that between the beginning date and the ending date, these 18 months, Ms. Gomez and this defendant conspired to defraud.
But it doesn't identify one drug or one incident for one indictment, another incident for a separate indictment.
That's correct. It does not do that.
Thank you, Mr. Lynn.
Thank you.